Um, today, today's webinar really uh, we've set just as the next rent payment date is coming, either 24th of June or what I call the metric days, the 1st of July. Um, the last quarter day hit us just as we went into lockdown, and really it was more a case of reacting afterwards, and landlords and tenants started speaking to each other and making arrangements after them before. So we thought it would be useful to sort of review those arrangements and to give people the opportunity to be ready for the next quarter day, and to have an idea of what has been done before. So Greg Callard is going to talk about the various arrangements which we have seen and done since the 25th of March, and some are still being documented. And then Caroline will look at the alternative for landlords if they do not want to do a deal and they want to be paid their rent. You'll all be aware that many remedies are currently suspended, but some are still available for landlords. Can I just say the webinar is being recorded, so that if you listen and want to listen to it again, or think colleagues ought to listen to it, then there should be that opportunity to do it via our website. And really, if you've got any questions during the webinar, can you please use the chat room to raise them, and we'll endeavour to answer them at the end. In fact, you keep the chat room open throughout, because during the webinar there'll be a couple of polls going up just to get feedback from you as to your views on what is happening with rent, and also we would very much welcome any topics for the future, as certainly it's in our mind to do another webinar as we run up towards the September quarter day. So that's the background. I've now asked Greg to talk to you about arrangements, and then when he's finished, I'll pop back and invite Caroline, and then the three of us will return to take questions at the end. Thank you.
Great, thanks, Peter. So as you probably are all aware, the Coronavirus Act of 2020 protects commercial tenants from eviction for non-payment of rent at the moment up until the 30th of June 2020, although watch this space, I think, is the message. The important thing to remember is that it does not remove their obligation to pay rent. Rent is obviously very much still payable, as are any service charge or insurance rent that may be due under the lease. It's important that buildings continue to be insured and safely maintained so that they are ready to support the economy's recovery after the COVID crisis. So any service charge and insurance charge payable under the lease, which isn't obviously profit making, must be paid in full. The main commercial advice we are giving and seeing both landlords and tenants taking has mirrored the government's advice to date of communicate. A large number of our landlord clients have reported back to us that they have been in open correspondence right from day one, really, with the tenants, and that seems to be very much the way forward. Although one particular landlord client of mine, their tenants have cut off all communication, which isn't proving particularly helpful. It's imperative that both landlords and tenants do enter into these open and honest discussions about how the coronavirus outbreak has affected them. Landlords obviously needing to be aware of the problems that their tenants are facing, and although there is generally a public feeling of less empathy towards landlords, they are obviously facing their own challenges. Landlords are urged to give their tenants some breathing space, and the government was asking tenants to pay rent, or at least part of it, where they can afford it, in recognition of the strains felt by commercial landlords. We suspect this will be little comfort to the landlords severely impacted by non-payment of rents by the tenants on the March quarter date, And obviously we're waiting to see what happens next week in the June quarter date, and as Peter mentioned, the 1st of July payment date, relating to the landlord's own debt and liabilities under their banking and finance covenants. Many occupiers, including Primark and New Look, struggling or have refused to pay rent when it was due in the last quarter date, which has deprived landlords of billions of pounds in revenue. The retail property group Into Properties collected just 29% of the rent due, Hammerson's 37%, while British Land was paid only 43% of rent due between the 2nd of March and the 30th of April. Almost 3 months on, the situation has deteriorated. The British Property Federation estimates just 15 to 20% of the 2.5 billion quarterly rent retail due on the 24th of June will be paid. Unless a landlord has agreed to waive the rent due for March quarter, then come July, many tenants who've been unable to pay some or all of this quarter's rent will owe up to 6 months' rent by the end of next week. Even if the economy returns to running at pre-COVID speed, which seems highly unlikely, most businesses that have been closed won't be able to make up all the lost trade, particularly those operating obviously in the hospitality and leisure sector. There are obviously some encouraging signs in terms of footfall, and the stats that we're hearing in relation to Swindon town centre was around 8,000 people footfall at the end of March in the height of the pandemic, and on Monday the 15th this rose to 23,000 people in the town centre, but obviously we don't know how this translates to sales and revenues. Where the landlord hasn't waived their right to claim rent and it remains outstanding, subject to the code which is being discussed and is under current review between landlords, which is the government-led code, which we'll cover a bit later. If landlords seek to enforce their rights, there could be thousands of business failures and investments in furloughs, rate release, business loans, could be argued could be for very little. It may be that smaller businesses that have taken advantages of all the reliefs and some of the larger businesses with deeper pockets will survive, but it could well be the middle section and sector that have particular difficulties. Landlords have taken generally a long-term and measured view. Simply asking landlords and tenants to cooperate may be not enough. Until the government intervenes, others were threatening enforcement procedures, and the fact that measures were required to indicate this shows that not all landlords want to take this approach, and I'm sure that Caroline will be covering this in her talk later. Tenants' leases do not generally require the tenant to provide a landlord with information about financial situation, showing whether cash flow issues are temporary or more long-term. However, we are seeing a trend towards landlords and tenants working together, being more open to achieve a practical and mutually beneficial outcome. It is recommended that tenants share this information with their landlord so that they understand that the tenant is not deliberately trying to avoid payment. There's also been renewed calls for turnover rents under the rent abatement proposal, which has the backing of several large companies. The suggestion being to have a national rent holiday for a period of time and potentially to make all rents turnover related until sales figures recover to pre-COVID levels as a minimum. Quoted reaction has been mixed. Retail real estate companies have publicly stated a code of practice that encourages landlords and tenants to talk to each other and recognise common interest has to be a good thing. However, retailers have to play fair. They're stating that if they're to move towards a system of turnover-based rents, retailers have to play their part and be transparent. Where they can, they should pay what they can. This bigger push towards turnover-based rents is seen as a positive one by a number of retailers. However, obviously the hardest part is implementation and transparency. The reaction of lenders obviously to these notions will be fascinating to watch. With the proposal that tenants don't pay landlords, lenders aren't going to see repayments, or at the very least landlords will struggle to make repayments. Therefore, it's clear that lenders will need to be involved and the math is likely to get very complicated. I mentioned the code earlier, which the Ministry of Housing, Communities and Local Government are rushing to publish to support high street landlords and tenants ahead of the rent collection date. It was created in consultation with a working group established by the government, including the British Retail Consortium, British Property Federation and UK Hospitality. The aim of the code is to provide clarity and reassurance over rent payments by encouraging discussions between landlords and tenants. It will also provide guidance on rent arrears and the treatment of subtenants and suppliers. Expected to be announced this week, it will add to the packages of protective measures introduced by the government for tenants in the commercial sector who failed to pay the March quarter's rent, which included the moratorium on forfeiture and the stay of possession proceedings, limitations on the use of statutory commercial rent arrears, etc., which is all points that Caroline will no doubt cover. It's understood that the BRC has called for an extension of the forfeiture moratorium in the code, the legislation preventing landlords to evict tenants by the end of June. They're calling for this to be extended to the end of the year. I should mention that as part of this open communication, landlords should obviously be informing the tenants of any schemes that they're aware of that may assist with their rent payments, such as small business grants, job retention schemes, deferrals, VAT payments and income tax payments. Looking at some of these specific options a bit further, we've discussed the waiver of rent. The first option is for the landlord or the tenant to agree to waive or suspend the payment of the rent for a set period and essentially offer a rent-free period to the tenant. This will not compensate the landlord, but allows the tenant additional breathing space and reduces the risk of non-payment of any future rent. This links back to the earlier point that it also negates potential enforcement action for non-payment of rent where this remains outstanding. Another option that we're seeing is rent suspensions, which can also be linked into extensions of the lease. So the landlord could suspend the payment of rent for a set period and extend the term of the lease by the amount of months the rent is suspended for. A point of caution is that extending leases and therefore extending the landlord's income period could be a good way of compensating a landlord for any lost or deferred rent. However, care needs to be taken to ensure that all the formalities are followed to avoid problems with land registry, stamp duty, land tax being triggered for the tenant, and inadvertently granting a new lease which has security of tenure. A third option is for rent deferment, where rent is simply being deferred to a later date, whether in a lump sum or a proportionate amount over different dates. For example, we've seen situations where the landlord's offered a 3-month rent deferment and the tenant pays 1 month additional rent at each subsequent anniversary of the lease, provided the lease has 3 years remaining on it. This obviously works. If the rent is deferred, the landlord will need to consider whether to charge interest on the rent arrears or not, although the code is pushing for landlords to waive any interest. The fourth option, which has worked well for a number of our clients, is dipping into rent deposits. So if a rent deposit is available, a landlord may decide to apply the rent deposit to cover the next rent payment. This eases the immediate pressure for both parties and allows the tenant to top up the deposit at a later date. Whilst this would be a benefit to both landlord and tenant in the short term, there's obviously the risk that the landlord would be left with little security should the tenant default in the future, and presumably no tenant would be in a rush to top up the deposit, although this should very much remain on the top of the landlord's agenda. This obviously shows a massive benefit for agreeing larger deposits at the outset. Pursuing guarantors for rent arrears, if available, may be more appropriate in most situations. As I say, a number of our landlord clients have asked us to check their leases to ascertain whether a break option is available to the tenant. Landlords should factor in any upcoming break options for the tenant, consider whether to offer any further options or incentives to the tenants. Landlords should also review their lease to consider whether the tenant is permitted to assign or underlet the whole of the lease, and this should also be factored into any discussions and decisions. Failing all of that, there's obviously the option for the lease to be surrendered should the tenant wish to terminate the lease early. It is at the landlord's discretion whether or not to agree to this, and the landlord can demand a lump sum upon compensation of the surrender. But obviously that's open to negotiation, but that may be an attractive option for both landlord and tenant. Landlord getting some money and the property back, and the tenant losing one liability off of their books. When considerations of any of the offers are put forward, the landlord may want to seek to offset with negotiating the removal of favourable terms to the tenant, such as a removal of a break right in favour of the tenant, an extension of the lease, or other agreements with landlords. One such client that we've acted for has, they've accepted a rent deferment and a rent holiday as well, and in return have removed the tenant's break option. One piece of information that will be coming out in the code that looks quite interesting and probably seems to be the most attractive option for landlords and tenants alike is the furloughed space grant scheme. Similar to the furlough for employees, it would require the government to pay some or all of the rent. The furlough proposal is loosely modelled on a successful Danish scheme, whereby the government subsidises the rent bills of stores closed in the pandemic. The underlying principles are the same of our proposal, that both parties involved take a bit of the pain, then the government steps in and bridges the gap. No one party takes an unsustainable part of the pain. Subject to any terms and conditions attached, this option does seem attractive to landlords, tenants and lenders, and one very well-known high street retailer client told us this was the best solution because rent expectations are currently unrealistic. Obviously watch this space this week. Ultimately, landlords need to decide whether to forego money now and assist the tenant with surviving the crisis, or whether to demand rent now and bear the risk of the tenant going bust. The landlord also needs to consider that they could help the tenant out now and the tenant could go bust anyway, so the landlord could effectively lose out twice. This is why we feel it is important for landlords and tenants to be open and possibly request and evaluate financial information before discussing potential options. The furloughed space grant scheme does seem very attractive, as we've said, and given the level of spending that the government has already injected to keep the economy afloat through the crisis, the government may be less convinced of its merits. However, if the alternative is millions of jobs and thousands of business lost, which leads to a severe recession, it might be a price worth paying. The cost to the economy of thousands of people currently furloughed being made redundant and businesses and landlords defaulting on loans may lead to an L-shaped recession rather than a V or even a U-shaped one. Whilst we wait on the outcome of these discussions and landlords and tenants discuss and make arrangements between themselves, it is imperative that any agreements made between the landlord and tenant are made in writing. The wording needs to be clear and unambiguous and should reflect what has been agreed, the parties for the period in question, which can be a fixed time or linked to a trigger event. It should also be considered whether any agreement is intended to vary the terms of the lease. Failure to do so puts the landlord at risk of issues in the future. And I will hand back to Peter now.
Thank you very much, Greg. Yeah, I mean the furloughed space grant scheme clearly is a very sensible way to go, as you know they've brought in the scheme now so we can bring back people part-time from furlough, as we can't expect to go from where we are today to full occupancy of buildings and full employment of staff overnight. It's going to be a phased return, and for the government to recognise that in terms of space just makes so much sense. I mean, probably like everybody listening, we've done planning as to how dense we believe we can occupy our buildings whilst observing the 2-metre rule and other social distancing requirements, and we reckon 40% is about the maximum we can occupy for the time being. So the government reflecting that with sort of 60% subsidy would be very sensible. Anyway, I'll hand over to Caroline now, who has a very unenviable task of talking to you about a situation which, as Greg was saying, is just about to have government intervention and changes. So a very, very difficult subject to talk about. But anyway, over to Caroline.
Thank you, Peter. I've been asked to talk about what landlords can do if their tenant will not pay the rent or reach an agreement in relation to the rent. The answer is not a lot, I'm afraid. As you know, and as Greg has mentioned, the Coronavirus Act, sections 82 and 83, impose a 3-month moratorium on forfeiture. Now, that's forfeiture by peaceable re-entry or by court proceedings. The moratorium applies to failure to pay rent, insurance rent, service charge, or payments reserved as rent. Now, the current moratorium runs until the 30th of June. We're expecting it to be extended, but there's no news on that at the moment. It'll probably come in, we'll probably hear on the 30th of June whether it's been extended or not. The moratorium applies only to leases that are longer than 6 months. Now, that's going to be most of them, obviously, but bear that in mind. If you've got a short-term lease, then that can still be forfeited. I suppose good news, if there is any in this particular element of of forfeiture and the moratorium, is that you can continue to demand the rent without fear of waiving the right to forfeit in the future. So you can, so that is good news. You carry on demanding the rent, and you're not at risk when the moratorium is lifted. If possession proceedings have been commenced and are ongoing, then the moratorium also prevents any orders being made until after the 30th of June, and that too could be extended, and we're expecting that to be extended as well. I suppose one good bit of news is that you can forfeit for non-monetary breaches of lease. Same usual process applies, section 46 notice and then forfeit. So if there's anything that else is going on, you can forfeit for that if you want to do, if the landlord wants to do so. The only, I think, slight wrinkle in this is that if you are planning to forfeit for a non-monetary breach of the lease, then demanding the rent will be a waiver. So just bear that in mind and have a think about what you plan to do and how you plan to do it. In relation to squatters and the like, trespass, possession proceedings can still be issued and will run through the court, depending on obviously how long the court takes to process them, but you can still obtain possession for that sort of thing. The other main weapon in landlords' armoury was, of course, the statutory demand against tenants, but that is on hold-ish, I suppose, at the moment. 23rd of April, the government proposed a temporary halt to the use of statutory demands and winding up procedures in relation to companies that couldn't pay their debts in relation to, as a result of coronavirus, and obviously that includes the rent. Now, this only applies to companies. It doesn't apply to partnerships and individuals. The thought is that the government thought that it would be covering off all potential businesses, if you like, but the wording of the draft bill that's going through Parliament at the moment just refers to companies. As I say, it's not just applicable to rent, but what it means is that you can't present a petition to wind up a company from the 27th of April to the 30th of June, or 1 month after the legislation comes into effect. And again, that can be extended, and we're expecting it to be extended. This legislation's been pending for some considerable time, and at the moment you can issue statutory demands and winding up proceedings, but the feeling is that the court is not going to be swift to put the winding up petitions forward. It's going to hold back whilst the government's legislation is progressing. So I think it would be perhaps a foolish landlord who goes down that route, or a brave one, or one who's got some money to burn, I think. The landlord can proceed by way of winding up if he has reasonable grounds for believing that coronavirus has not had an effect on the tenant's business, or that the debtor would have been unable to pay its debts anyway. Now that would be quite a forensic approach to have to take. We haven't seen any cases going through the court yet, because obviously the legislation isn't in. I mean, yeah, there are circumstances, I think, where you might be able to prove that, but it's going to be few and far between, I think. But just to bear that in mind. At the moment, the courts are not operating particularly swiftly. All the process is very slow. They're doing video hearings. And there's not very many people operating in the offices either. They are working through winding up orders in relation to pre-coronavirus debts. So companies may still go into liquidation at this time in relation to debts that have been incurred previously. So I think keep an eye on that for tenants. But no new process is going to be worked through. I suppose, is there any good news? Well, interest continues to run, as Greg mentioned. You can go after guarantors if there are any on the lease. You could statutory demand a guarantor who's an individual. I think in relation to a guarantor that's a company, I think the same issues will probably arise as in relation to a tenant company that I've mentioned previously. You can make use of money in rent deposits, follow whatever the process in the rent deposit deed says and deduct from that. CRA, commercial rent arrears recovery, continues to operate, but the arrears must equal at least 90 days rent arrears, and you can't use that process against unoccupied premises. So it's a difficult one to utilise at the best of times, and I don't think it's been made any easier for the landlords at the moment. What does remain available is the issue of county court proceedings for the debts in the usual way. There is, on the face of it, no defence to a county court or high court claim for rent, and most landlords, if they issued proceedings, would apply for summary judgment, and in the usual course of events you would get a judgment very quickly, probably within about, quickly in terms of court proceedings, within about 2 months. And obviously the entry of a judgment can have impact on credit, etc., etc. As I've said, the court isn't working particularly quickly at the moment in processing proceedings through directions, etc. You can get court proceedings issued quite quickly. So if you've got a tenant that isn't talking and is being particularly difficult, then we can issue court proceedings. We can get them issued and served, which will often give the tenant something to think about and hopefully start to negotiate. If the tenant does put a defence in, we can apply for summary judgment. But when we're going to get that summary judgment heard is another question. I really don't know. It's going to depend court to court as to when that comes through. And then we've got the usual issues about, even if you do get a judgment, how are you going to enforce it? Well, we can send the bailiffs in if the property has got stock or something in there. But until the position in relation to winding up and statutory demands change, a judgment can very much be a paper thing rather than anything of any substance. So I suppose there's little crumbs of comfort in there for landlords, but not, I'm afraid, a huge amount. But Peter, back to you now.
Thank you very much, Caroline. It's interesting, whilst Caroline's been speaking, we sort of published the poll about whether people think it's going to be worse in September than now, and I'm encouraged by the fact that it's not as pessimistic as I was expecting. It's 50% are saying yes and 33% no. But the suspension of landlords' remedies, which Caroline's been talking about, clearly is going to be important from a tenant's viewpoint, that they remain in place. But clearly there are many landlords who probably do want to take some remedies, and there probably are some businesses which are not going to survive, and the landlord therefore wants to get in as soon as he can, and will be frustrated. This is the webinar which we recorded last week about the forthcoming rent payment date. After we did the presentations, we received some comments and questions from those watching the webinar live. I thought it useful just to sum up 2 or 3 of those. Largely the main question was whether we are seeing any changes in lease terms as a consequence of the current pandemic, and in particular, are we seeing COVID clauses, as they're being termed, inserted into leases? The answer we really gave is that in the short term, we're not really seeing a big change, as not that many leases are currently being negotiated, but certainly into the short to medium term, we expect to see some changes with shorter leases and possibly more frequent or rolling break clauses. One thing in particular which we are seeing at the moment are clauses to deal with rent suspension should there be another second lockdown, if the current easing of restrictions causes the pandemic and the R rate to rise again. Since the webinar, 2 things really have happened. One is that the government has issued its code of conduct for landlords and for tenants, and the other is an increasing sense of concern on the part of landlords that not much rent is going to be paid on 24th June or 1st July, whichever is the rent payment date for the relevant commercial lease. If we can help you with advice or assistance about the payment of rent and reaching of agreements between landlord and tenant, please do feel free to get in touch with us, and we will be very happy to give you the benefit of our knowledge and experience. Thank you very much.